enter any personal information, addresses, phone numbers, things like that, social security numbers, into the chat because this is being recorded and it will be uploaded to YouTube at a later date. And once the meeting concludes and that recording is uploaded to YouTube, I will also email out the slides that we have here today and a link to that recording. So, with that little spiel out of the way, I will turn it over to our attorney, Ben Kaufman here, who's going to be educating us today. So, go
Thanks
ahead,
so
Ben.
much, Isaiah. I appreciate it as always. If you're here today, it means that you registered for today's monthly virtual education presentation, which we've called Anything But Advanced Directives, Other Tools for Life Planning. Spoiler alert, there's a little bit about advanced directives, mostly as points of comparison, and I get back to them. Focus really is on what other tools are available to help with some of the same things as advanced directives. I'll talk about the extent to which they sort of can meet similar goals or whether they do different things as we go. So as always, I'll talk a little bit about who we are, about this program, and then I'll get into the primary topic for today. So who we are is Southern Minnesota Regional Legal Services, or SMERLS. We were founded in 1909, making us the oldest civil legal aid organization in the state of Minnesota. We are currently celebrating our 115th birthday this year. We provide free civil legal help for those in need in 33 counties of southern Minnesota. And what does that mean to be a free civil legal help organization? We're a legal aid program, which means that we take cases that don't generate fees or that private attorneys just won't take. Uh, some of those areas that private attorneys won't take and that aren't fee generating can include our housing unit, our consumer unit, our economic justice, which is our public benefits unit, our family law unit, education unit, immigration unit, our unit, the Legal Advocacy for Older People Project, or our seniors unit, the Agricultural Workers Project, and a hotline. So a little bit more about our unit in particular. LAOP is funded under the Federal Older Americans Act to focus on issues that affect people age 60 and up in the greatest social and economic need. We provide legal information, advice, and representation, and we cannot means test. So that means that we do not use income and assets to decide if we help, but we still might have to collect that information to determine how we can best help. Really, it's all about determining whether your issue is one that the Older Americans Act funds our work in. Some of those areas of work include elder abuse and exploitation prevention, evictions, nursing home discharges, assisted living contract terminations of services and or housing, termination or reduction of care services, appeals of public benefit denials, reductions, or terminations, fair housing, reasonable accommodations, and more. You are here today as part of our online learning programming. LAOP offers these every month of the year, presentations on topics of critical legal importance to people over 60. Uh, Next month's presentation is going to be held on Monday, December 16th. And we do not yet have a title or full summary, but on changes in Social Security after 2024. For more information and to register for that and future upcoming presentations, you can go to our webpage for online learning. The website is there on the slide. If you are currently dealing with an issue and it may be a legal issue, or you want to know what your rights are, or you want to know if there's a legal solution to a problem that you're facing, telephone's the best way for prospective new clients to connect with us. You can call us at 1-877-696-6529 from 9 a.m. to 3 p.m. during weekdays and non-holidays. Prospective clients can also apply for services on our website at www.smurls.org. In addition, if you are in an area that is near a legal kiosk, you can also use those to get in touch with us. If you want information on legal kiosks or you're just looking for information about legal help, you can go to lawhelpmn.org. Uh, if you are calling, but you need, and you, because you need assistance, but English is not a language with which you are fluent, or people that you know are in such a situation, we employ personnel who speak Spanish, Somali, and other languages that are commonly spoken by our client base besides English. We use a service called Language Line to provide interpreters when neither our staff nor existing community supports are available. That interpreter service is at no cost to the client before we've even agreed to represent. So, with all of that information out of the way about who we are and what we do, here's what we are not discussing today: advanced directives. So, what is an advanced directive? An advanced directive is a document that allows you to share legal authority and or provide legal instructions over your affairs. Generally, we're talking about in the areas of your personal estate when you pass away, your finances while you're alive, or regarding your health and healthcare. So as we'll see, the examples of each of those types of advanced directives are wills, powers of attorney, and healthcare directives. So the power of attorney is an advance directive that gives permission to another person to act for you in areas other than healthcare. So very broad, but you can generally think of it as finances. The healthcare directive gives instructions, permission to give instruction or both for your healthcare. And a will is a document wherein you give instructions for handling your property and debts after you pass away. There's a lot of reasons that I hear that people don't want to look at advanced directives like those three documents as planning options for them. The first reason is the cost. A lot of people think that you have to work with an attorney to get an advanced directive in place. While it is generally recommended, that can mean that there's a pretty high cost to obtaining them. Belief that they're unnecessary. A lot of people think that these documents are really only about putting plans in place if someone's becoming losing capacity, becoming dependent on the assistance and direction of others, and you don't anticipate that you are going to fall into that category anytime soon, and so you simply don't think that it's needed. Lack of trusted people. Uh, a lot of times when the thought of who is in my life that I trust enough to act and make decisions on my behalf, an answer that some people unfortunately experience is I don't have anyone that I trust enough to fill that role. And a lot of times, another reason is simply lack of knowledge. I don't know what advanced directives are. I'm not interested. So setting those three aside, wills, powers of attorney, and healthcare directives, here's a brief survey of tools that I'm going to talk about today. So again, these are not legal instruments. These are other forms. Well, I shouldn't say that in the estate case. In the health and finances case, these are forms that you are getting filled out or filling out yourself uh, that can do similar things to providing authority to someone else to help you or providing instructions for what you want done. So we'll start with health. We'll talk about the provider order for life-sustaining treatment, that's also known as a POLST, and the do not resuscitate order, which is usually abbreviated as simply a DNR. With finances, we'll get to this when we get to this section. The only option or tool that I'll be covering today is the representative payee system with Social Security. With the state, we'll be talking about three tools that you can use to transfer property. Uh, the transfer on death beneficiary, the transfer on death deed, and the transfer on death title. And the order of these is actually slightly different from the way they appear in the presentation. The transfer on death title is now known as a transfer on death beneficiary for vehicle title. So That is why it's abbreviated here as simply transfer on death title, and I'll cover that before I get to the transfer on death deed. So, with health, we are talking about advanced care planning tools, the POLST and the DNR. So, provider orders for life-sustaining treatment, or POLSTs, provide instructions to emergency medical services, medical professionals, hospitals, and long-term care facilities. They are composed of four sections, which I have actually copied and put into the presentation so we can look at them what on the Minnesota form in just a moment. But generally, the four sections relate to CPR, whether you want CPR if emergency services, medical professionals, you're in a hospital or long-term care facility, if you are found to have no pulse and you're not breathing. Um, as we'll get into when I talk about the DNR, this section by itself is essentially the same as a DNR. Next, we'll look at medical infection, different treatment goals. Um, they reflect whether you want treatments including intubation, surgery, or ICU, but they categorize the goals and whether you want to refuse those types of procedures or treatments under more general descriptions, which you'll see in a moment. Antibiotics, when you want them used. And then lastly, artificially administered nutrition. So if you're not able to eat, whether you want uh, other means of receiving nutrition. Um, one thing that you'll note if you have any familiarity with POLST is that although the form that you'll see is white, that's because it's the printer file. But in fact, when POLSTs are printed out, they are always done in very bright colors. And the reason for that is that they are intended to stand out so that emergency medical service providers, EMTs, ambulance staff, can see it immediately if you have one so that they can then review it, find it, review it quickly, and then administer whatever aid is necessary and in accordance with the wishes in the POLST. So as I said, we'll look at the sections next. So as you can see, under the CPR section, where the patient has no pulse and is not breathing, you simply identify whether you want to attempt resuscitation and CPR. You do need to select full treatment if that is the case, or you can identify that you do not want responders to attempt resuscitation, which again is the same as a DNR. In other situations, so if you have a pulse and or are breathing, whether you want to pursue full treatment, selective treatment, or comfort-focused treatment. And what you'll see at the very bottom, I won't go into the full details of each of those treatment levels, but identify that that treatment plan captures the idea, what the goal is under the HOLST. So if you're seeking full treatment, you're seeking life support measures, including going to the ICU, in order to prioritize life, your life continuing. If you want, on the other hand, comfort-focused treatment, what providers are going to do is not use treatments that are going to make you uncomfortable. They're going to prioritize symptom management rather than potential cure. Selective treatment then is something in the middle. It says in the form, providing basic medical treatments aimed at treating new or reversible illnesses, but it's not as aggressive as a full treatment selection. So this is something that we'll get into in a moment, but the POLST has to be discussed and signed by your by you and your healthcare provider. As you can see, that can be your physician, an APRN, or a PA. So first, they're going to identify that they've had an opportunity to discuss the document with you. And as you'll see here, it can be with you, a court-appointed guardian, a parent of a minor, a healthcare agent, or under a healthcare directive, and with other surrogates. If you are deemed to have capacity, um, it is always a good idea for you to personally sign your own post. But it actually requires the signature of that healthcare provider as well. And I'll get into that in a little bit. Here, this section E is where the artificially administered nutrition and antibiotics sections are included. You'll see here that really it's about artificially administered nutrition is feeding by tube, whether you want that long term for as long as is needed, if there's only a certain period that you want artificial nutrition administered in that means, or if you want to outright refuse uh, feeding by tube indefinitely. Uh, then with antibiotics, as a non-medical professional, I won't speak to the specific differences here. My assumption is that it's essentially referring to injectable antibiotics versus oral antibiotics that you would take through the mouth, or refusing antibiotics, period, and using other methods to relieve symptoms.
We have our first question here, Ben Quick.
Sure.
Yeah. Is there a reason why doctors will still verify with the patient after an expressed desire for a DNR, DNI pulse? Do they still ask even after a DNR wristband has been affixed? Do you know anything about that?
Uh, My guess is that it is going to be to reflect a legal requirement that healthcare providers must follow when executing a pulse. By execute, I just mean signing. So pulse, as you see in the name, the O stands for order. And that is because a pulsed or a DNR, as I'll get to in a moment, are both medical orders. In fact, in some other states, rather than provider orders, a POST might also be called a provider order for scope of treatment, POST, or a medical order for life-sustaining treatment or medical order for scope of treatment. The reason that of that emphasis is that this is not a legal document. This is a medical order by your physician or provider. It has to be made in consultation with the provider and signed by that provider. And so my guess is that their decision to verify, yes, you understand how you have filled out this form, or how you have answered questions leading to the filling out of the POLST or DNR, is in accordance with your actual issues, that it hasn't been influenced by someone else, or that someone else speaking for them has accurately summarized the the will of the person, of the patient. Um, Something else to note. I hope that answered your question. You can feel free to add to the chat if you have further clarification that you would be looking for. But in the interest of time, we'll move on. Um, Now, note that your provider is going to recommend using it in light of advanced disease, circumstances of frailty, or terminal conditions. Um, what that means is that you can't go into your doctor's office tomorrow without any diagnosis, without any injury, just a clear head and wanting to get a plan in place and demand a pulse. Um, it's really only for situations where it's going to be imminently necessary. Um, because of that intention, that it be for situations where emergency services are going to need to see what your wishes are immediately. The recommendation, and providers will echo this if you have one drafted, is that you keep it on file with any local hospitals that you may be brought to, with any providers that you may be brought to, and to keep them on hand for emergencies. Like I mentioned, they're usually printed in very bright colors. Um, if you are living in a long-term care facility, they might be kept literally next to your bedside. I've seen facilities where there is a little plastic sleeve that goes right on the nightstand that posts are slipped into. And when the copy of this presentation goes out, you will be able to look at the website where you can review all of the slides that I just showed you to see what the actual post looks like. But that's the information that I have on that for today. So you'll see this slide on the do not resuscitate order is going to look really familiar. DNR order is made in consultation with and signed by your healthcare provider. It is essentially a pulse that only covers respiratory resuscitation. And you can go to the link there where the form is available. So some limits of those tools. Your provider has to agree to make the order. If your physician or provider refuses to help execute a PULST or a DNR, you can't go around them. You could visit another provider and ask them to do the same, but ethically, the same limitations are in place. Additionally, if you lack capacity and you don't have plans in place already, other advanced planning documents, um, you can't participate if you lack capacity as determined by your physician or healthcare provider. And then additionally, the instructions that you can leave are limited to the named sections. Although on Minnesota's form, I should rectify, there is a space to leave other general healthcare instructions. So having talked about some of those limitations, we'll turn now to talking about finances. And in particular, I'm going to emphasize the representative payee. So the representative payee program is available to recipients of Social Security, that's retirement or disability income, or the Supplemental Security Income Program. And essentially, the REP payee program allows someone else to manage the payments distributed by Social Security. The Social Security Administration is going to look to family or friends first, then to qualified organizations. Uh, you can fill out a form to request a REP payee in which you can designate three alternatives in advance for Social Security to contact. And I've included a link here on the web page for how to uh, information about the program and how to obtain the form to obtain a REP payee. Something in terms of accountability for the representative payee program is that REP payees must fill out an annual report to account for benefit payments that were received. So what account they were deposited in and how they were used, except in four categories. So that all are based on who the REP payee is. If they are a natural or adoptive parent of a minor child beneficiary who primarily resides in the same household, if they are legal guardians of a minor child beneficiary who primarily reside in the same household, natural or adoptive parents of a disabled adult beneficiary who primarily resides in the same household, and if a spouse is the REP payee, they won't be required to render the account. But again, there are limits here. You will note that the REP payee only allows management of Social Security payments. That is, there is no inherent authority once assigned a REP payee to use or interact with other income sources or accounts. And generally, all of these payments are going to have to go to one account. So if you are a REP payee, but the Social Security benefit has other private accounts with no other account holder named, you being named REP payee doesn't give you authority to manage that other account. You also can't represent the beneficiary in contracts. Your job is to fundamentally make payments that are owed using the Social Security funds and to set up the account to receive the funds. And then also, there's no authority to manage real estate. We'll get to why this is a shortcoming uh, in a greater shortcoming than it might appear in a little bit. So, having looked at the Rep Payee program for finances, we'll look now to estate tools that are the most similar, arguably, to a will. We'll look at three transfer on death programs: the transfer on death beneficiary for accounts, beneficiary for vehicle titles, and the transfer on death deed. So starting with the beneficiary accounts, uh, it's very straightforward. You're simply naming someone to receive ownership of the financial account with the bank without giving them access to the account before death. So in other words, they can't use the funds while you're alive. It's only after you pass away that total ownership of the account converts to that person. It does avoid the probate process. It no longer has to be administered by a court, even if the rest of the estate does pass through probate. Just know each financial institution is going to have its own forms and may set its own limitations on who can be a beneficiary, when a beneficiary can receive. Uh, because of that variation, I don't have links to specific examples or further information at this time. You would have to confirm with the financial institution managing your own accounts to determine where to access transfer on death beneficiary forms and, like I said, what limitations there may be. So turning next to the transfer on death beneficiary for vehicle title, it's a form filed in addition to the basic vehicle title with the Department of Motor Vehicles, in which you name a beneficiary for title to pass to after your death. So once again, the whole idea here is that we are avoiding probate. Your vehicle title will not have to pass through probate to be transferred to the recipient. Um, and you can revoke it at any time before your death, and it doesn't require the permission of the original recipient. How do you complete it? You have to sign it. It has to be notarized, and well, not with the county recorder. Apologies here. You do need to record it with the Department of Motor Vehicles. The transfer on death deed, similarly, is a form that allows you to name a beneficiary for title to real estate to pass to another after death. As a note, when you complete the form, you can name more than one recipient and you can name a successor in case that recipient predeceases you. So if they die before you, you don't necessarily need to issue a new transfer on death deed or rescind the previous one. Uh, if you already have named a successor, that's all you need to do. Once again, the added benefit of the transfer on death deed is that the property doesn't have to pass through probate to be transferred to the recipient after your death. Like title, you can revoke it anytime before your death, and it doesn't require the permission of the original recipient. It must be signed, it must be notarized, and then the transfer on death deed must be recorded with the county recorder before your death. So there's a link to where you can find the form as well as more information on the transfer on death deed. Um, Going back a slide, um, the advantage of avoiding probate is a generally well understood advantage here. The transfer on death deed not having to go through the probate process makes it much more financially efficient. There are some other reasons to consider a transfer on death deed as well, other than a will. One of those reasons might be to avoid gifting property to someone else while you're alive if you're trying to avoid, for instance, estate tax. The transfer on, if you transfer property during your lifetime, especially real estate, which is extremely valuable compared to other personal assets. If you transfer the property within 5 years of needing to apply for public benefits like medical assistance, which is Minnesota's form of Medicaid, that transfer, if you didn't exchange it for full market value of the property, can lead to the assessment of what's known as a transfer penalty, wherein the county says you should have sold that property rather than giving it away. That means that you gave this financial gift to someone else when you could have sold it in order to preserve more financial assets to pay for your own medical care. In that situation, you will be barred for some period. It's called the transfer penalty period, based on the value of the property that you gave away. Using the transfer on death deed actually does avoid the transfer penalty because you can file a transfer on death deed. The deed is recorded with the county recorder, and upon your death, title automatically passes to the beneficiary named in the deed uh, without having made the transfer during your lifetime. As I'll get into in a moment, that does not mean that it avoids things like estate recovery. That is a large fear, though, that a lot of people have. And unfortunately, the transfer on death deed is not a way around that process. Uh, However, the transfer on death deed is a way around uh, the transfer penalty, preventing you from accessing needed benefits to pay for care. So that is something to consider. So some limits of these estate planning alternatives. So I mentioned here, they may avoid probate, but they don't necessarily avoid estate taxes or debts of the deceased. And what I mean there is, even if you skip the probate process, if uh, if if unable to pay estate taxes, or if your debts are greater than the value of liquid assets that you currently hold. In other words, if you owe more money than you have in cash in savings or some other investment, um, creditors can seek to collect by filing liens against property that you left in a TOD or left in a transfer on death title, or where you have a beneficiary named on the account. Uh, Additionally, beneficiaries for vehicle title and deed transfers the property subject to any liens or mortgages that exist at time of death. So don't think that you can file a TOD, transfer on death deed, or beneficiary for vehicle title form, and your mortgage on the house will go away. Your outstanding payments for the truck go away after you die. Not necessarily. Now, if you only used those two forms to pass a house and a vehicle, if you have liquid assets, so again, cash in accounts that can satisfy any outstanding debts, you can simply use those liquid assets to pay off mortgage or other lines of credit. Uh, However, that's something that you would have to do at time of death, when you receive the house or the vehicle. They still have those debt lines attached. Um, the other thing too to note is that the transfer on death deed only applies to the home and not personal property inside. So, like I said, I do apologize. I broke my promise. I am going to talk about why you should consider making advanced directives. I'm going to emphasize again some of the shortcomings that I've identified throughout the presentation, and I'm going to emphasize an important issue here that advanced directives are intended to address. It's the question of who decides when you can't. So, in matters related to healthcare, this is another part of the POLST form that I didn't include before, which I'll read to in the entirety. A note to patients and surrogates. The post form is always voluntary and is for persons with advanced illness or frailty. Holst records your wishes for medical treatment in your current state of health. Once initial medical treatment is begun and the risks and benefits of further therapy are clear, your treatment wishes may change. Your medical care and this form can be changed to reflect your new wishes at any time. However, no form can address all the medical treatment decisions that may need to be made. A healthcare directive is recommended for all capable adults, regardless of their health status. A healthcare directive allows you to document in detail your future healthcare instructions and/or name a healthcare agent to speak for you if you are unable to speak for yourself. What I want to emphasize there is that last sentence. You can leave instructions more general or more specific than are included in the post form, which, as you saw, just has the opportunity to check boxes and a few lines for further instructions, and or to name a healthcare agent. And I know that it can be a problem to find someone that you trust to fill this position. However, if you do have someone that you trust, that you can talk through what your wishes are and ask them to faithfully follow those wishes, there is absolutely no reason not to seek out a healthcare directive and to consider naming a healthcare agent. You don't have to. If there's not someone that you trust, you can simply leave instructions. If you are familiar with estate planning advanced directives, one of those that you might have heard of is called a living will. In Minnesota, we consolidated the living will and the healthcare power of attorney into the healthcare directive. And when you fill it out, you have the ability to decide if you want to name an agent or leave instructions or both. So even the Post recognizes that it is not the be all end all in healthcare planning and recommends pursuing a healthcare directive. Uh, for that reason, healthcare directives can support provider order for life sustaining treatment or a DNR order, but they can be more flexible by allowing you to name an agent. Additionally, you can write your healthcare directive whenever you want. You don't need the input of a physician. You can do it with the support of a physician, but you don't have to. And you can do it whenever you want as long as you're of sound mind, which means that you can put the plan in place, have it executed and ready while you have capacity, while you trust your own judgment, so that there's no doubt later on that the document that you drafted does fully encompass your wishes. For finances, as you saw, I only brought one example today, and that's the Rep Payee program. That's because there really is no other document or tool that does what a power of attorney allows. The power of attorney can allow someone to apply for benefits on your behalf, to retain an attorney to represent and assist you with legal issues, to sell property for you, enter into contracts on your behalf, and more. And so, although the Rep Payee program is very essential for recipients of Social Security benefits, it's only for people who are recipients of Social Security benefits, and their authority really only extends to using those Social Security benefits on behalf of the beneficiary. Without a power of attorney, if you're in a situation where you need to sell real estate, uh, your rep payee cannot do that for you. They cannot hire an attorney for you if you're experiencing maltreatment in a care facility. They cannot submit applications for benefits on your behalf. For estate planning, the fact is, as I mentioned, the transfer on death, beneficiaries, and deed are both extremely helpful tools to help you pass assets without them needing to pass through probate. But the fact is, None of those tools help you get around estate taxes or dealing with other debt. Furthermore, if you have wishes for your belongings or unusual assets, you should look at a will as a way to most clearly express those wishes and guide distribution of your estate for your loved ones. But again, that's not to say that a transfer on death beneficiary named on your account, transfer on death deed for your home are bad ways of planning for your future. But despite the cost, it really is best to talk to an attorney to figure out whether these tools are going to be the best way to first capture your wishes for your property and assets, and then furthermore, to explain what tax liability there might be for the recipients to help ensure there's a plan in place regarding debt so that the things that you pass on go to your loved ones to the fullest extent that they can. And they don't have to pay for an attorney to help them untangle the situation after the fact. And the second really important thing to consider is advanced directives are important because they help decide who decides when you can't. I mentioned in particular with the example of the healthcare directive that the healthcare directive is a way for you, when you are of sound mind, to leave instructions or name an agent that you trust. If you don't take the step of naming a healthcare agent, if someone needs to make decisions about your healthcare and no one with legal authority has that capacity to make those decisions, then someone, whether that's adult protective services on behalf of the county, whether it's a concerned loved one, uh, a spouse, or a child who does not have legal authority to make decisions for you, despite that relationship, they'll have to petition the court for a guardianship. Now, depending on the circumstances, it doesn't have to be a guardianship. Minnesota emphasizes the usefulness of a tool called supportive decision agreements. That is a whole presentation on its own and is also still technically an advanced directive. But so that's why it's not appearing in the presentation today. But in the worst circumstance where you absolutely no longer have the ability to make decisions for yourself, then a court is going to assign that authority to someone else. If it's a matter of managing your finances, the court can appoint a conservatorship, establish a conservatorship, and appoint a conservator. If you take the initiative ahead of time, you can fill out a power of attorney to capture who is going to be responsible for making decisions when you can't regarding your finances. To hire an attorney to go after someone who maltreats you in a care facility, to sell your real estate so that you can qualify for benefits if you need to make an application for something like medical assistance, uh, to manage not just your Social Security income, but pension payments, any other retirement accounts that you may have been saving for your entire life. And then lastly, with a will, if you execute a will and you also have not utilized transfer on death deeds, transfer on death beneficiary programs, then you'll need to go to a court, and a court will impose what's the legal strategy for distributing your property after you pass away, called intestate succession. Now, that default intestate succession prioritizes family, which may be totally in line with your wishes for how you want your property to pass. But I want to stress that is blood relative family. If you are part of a blended family where you are not an adoptive parent, if you are in a position where you want some or all of your assets to go to a charity or other nonprofit organization, a church that you're passionate about, if you don't have a will, that property is not going to go to any of those other places. Intestate succession prioritizes a married spouse, then your children that are shared, then your siblings, then your parents, aunts, and uncles, and then it's next of kin. At no point will a court going through the intestate succession lines of inheritance ever find friends, non adopted children, or uh, organizations that you care about. Now, your family can make those distributions after the court administers intestate succession, but there's no legal requirement that they follow those wishes at that point. That will only be their faith in you, uh, their desire to comply with your wishes. There's no legal authority behind it. So, for those reasons, consider using a power of attorney, a healthcare directive, and will, these advanced directives, to help decide when you can't. Thank you all very much for attending the presentation today. I know I broke my promise. I said I wasn't going to talk about advanced directives, and of course I did. No good lawyer who works in elder law would completely trash the power of attorney, healthcare directive, and will as important documents. But I hope I've shown you some other documents that you can be aware of for planning for your health, finances, and estate. And I'll stick around and answer questions for the remaining time.
Fantastic. Thank you, Ben, very much for all that. That was definitely super helpful. And yeah, we don't have any new questions right now. So yeah, if anybody has any additional questions that they'd like to ask, yeah, please type them in the chat now. We will give it a minute or two. And otherwise, if you would like to head out, you are welcome to do that as well. So.
I do see a question in the chat. Thank you, Chris. Is there any legal value to a distribution list? If it is not part of a legal estate planning tool like a will, no, there is not. If you simply leave a written list, um, even if you sign it, if you have not filled it, if you haven't signed it in a way that is similar to the way that you would execute a will, a distribution list is just a list of your wishes. There's no legal authority that can compel distribution in accordance with that list. So all personal items must be delineated out in a will. Um, Again, if your desire is that your possessions go to your immediate family, to a spouse and children, uh, then no, you don't need to. You don't need to. Something that can be helpful is if you want possessions, for example, to be split between your natural children and a spouse who is not the also the parent of those children. You can leave a something like a distribution list that identifies the value of each item and where you would recommend how you would recommend splitting them. Um, because the intestate succession rules do have there are limits on uh, in situations where you have a spouse at time of your death and children who are not the children of that spouse, 50% goes to your spouse and the other 50% is split between your children. If you have a distribution list that clearly lays out what 50% could go to your spouse and how the 50% could be split evenly among your children. Um, they can follow that distribution pattern, but again, there is no legal way to enforce it because without a will, your list does not have legal authority. They can split it in whichever 50-50 manner they ultimately come to. Yes, if you want very specific items to go out to very specific people, in will drafting, there's a term called uh, I believe it's a specific bequest. Um, that is where you identify one item goes to one person. You can of course make it more than one item, but you're very clearly identifying this one or these items are identified and should be distributed to this one or group of recipients.
It just has to sort of be bound to the will to have that kind of legal authority in case, to kind of prevent disputes and things like that.
Exactly.
Okay.
The idea of the will is that the formalities of signing it, which is why it's so expensive, um, that what a will does is it gives very specific instructions about individual or general possessions, where they should go, to whom, how. You can identify which items should be sold first in order to pay off any debts that exist at the time of your death so that you can maximize the types of assets onto your children that you want going to them. Um, so, for example, if you are living in a home, in your home, your property that you own, and you know that your kids don't necessarily care about inheriting that particular property, but maybe there's a vehicle that you own on which there's still a mortgage. Maybe there is uh, or maybe you have a collection. Maybe you have a specific financial account that you want passed on. You can indicate in your will that you want the house sold, you want the property divided up in whatever manner you please, by your instructions, or leaving it to your survivors, to say, distribute that as you want, and then I want you to sell the house, and I want you to split the proceeds in equal parts between you. Or I want the proceeds to go specifically to paying off, the rest of the loan on the car, so that whoever's receiving it receives it free and clear of any debt. Those are types of instructions that you can leave in a will that there's no other legal instrument that is going to be able to capture and replicate. But really good questions. It can, if you have a lot or unique personal property, having those kinds of distribution lists can be helpful. But again, without the formal legal authority of a will, you can't guarantee that that distribution plan is followed. You can just ask that it be followed.
Awesome. Thanks, Ben. Oh, we have another one, Ben. Yep, there you are. You see it.
Yes. So the question is, what is the difference between a trust and a will? Um, that question honestly could be its own full hour-long presentation. So I apologize. I cannot answer um, I can't, it's beyond the scope of what I can answer in this presentation. What I will recommend is if you go, let's see, it won't take me back to the slide. Oh, there we go. And I apologize for flipping quick here. Ah, sorry. Lawhelpmn.org is going to be a great resource for you to look up fact sheets, frequently asked question, uh, answer responses to frequently asked questions. Um, uh, I believe there is information there on what is a trust and what is a will. Principally, a trust is something that you establish while you're alive, while a will is a document that has authority about how your possessions are distributed after you die. Sometimes a will and a trust are used together. Sometimes people only get a trust created. Sometimes people only have a will. So I can't go into any more detail than that. We would have to stay much, much too late. But you can at least start research on that question at lawhelpmn.org. And then another question, how often do families contest wills in real life? Um, that's a fair question.
Hmm.
And having gone through law school and having read a lot of opinions about contested wills, I may have an overinflated sense of the likelihood of that being a problem. Um, Again, the problem ultimately comes down to without a will, your preferences are only that, preferences. It's someone else who is going to make the decision about how things are ultimately distributed, and your preferences will be notable, but they aren't mandates, and no one can force someone else to abide by them. So, how often do families contest wills in real life? I can't really say,
Hmm.
but
Hmm.
I would not be doing a good job as an attorney if I didn't say it is a possible problem and it is a problem that can be avoided if you have a will.
Hmm. Hmm. I think in inside of our elder law meetings, Ben, yeah, every week, I think we do see one or two, yeah, issues around, si siblings or family members, with questions about trying to contest a will or being interested in contesting a will. So yeah, I think we do see that. I think we do see that, not too uncommonly. So yeah, yeah, I think it's definitely something that can come up and folks should be concerned about.
But something that I will say to consider is that one of the best ways to avoid situations where people contest a will is to just get everyone on the same page. So often, the version of those calls that Isaiah described is so and so claims to be the executor. I haven't seen the will. I don't know what it says. So one of the ways, obviously we all want to be, the person who's in a magnificent coffin and the family attorney appears in a suit at the wake and is preparing to read how property is going to be distributed, and everyone is aghast and surprised. But the best way to avoid will contests and murder mysteries is to in advance, sit down with everyone who's going to receive, walk through the will. You'll have an opportunity to receive questions, and you can actually do this before the will is actually signed and executed. Or you can just say, I've met with my attorney. The way that this will is drafted is going to make sure that what I want to happen happens. And you can walk through what that does. I hope that helps. I certainly Uh, I didn't mean to scare you away from a will after talking about how beneficial they can be.